My warm greetings. I'm Irakli Kartvelishvili, Investigation Service of the Ministry of Finance of Georgia. It is a great honor for me to take part in this very important event organized by SAC Patenti, or National Intellectual Property Center of Georgia. A lot of employees from our service or agency are attending this event, and I do hope that we will have very interesting and fruitful conference. As concerns my presentation itself, the main topic of my presentation is investigation of intellectual property rights infringement and criminal proceedings, how criminal investigation is conducted regarding IPR infringement, and I will cover some topics regarding criminal proceedings as well. I will try to tell you very brief regarding the structure of investigation service of the Ministry of Finance. We have the legal status of the service, and we have sub-department of the Ministry of Finance, a special law enforcement agency, and the tasks of the services: prevention, detection, and suppression of crimes committed in the financial economic field or sphere. And for the purpose to investigate of the cases, we do not have a special task force responsible for investigation of alleged crimes, but still we have a very dedicated group who are responsible for investigation of cases belonging to the subordination of the service. This is the structure of our service itself, and this slide showcases the structure of our department service. Main department is investigation department, definitely, that consists of different regional services, including our division. We have specialized division responsible for customs-related infringements. In addition, there are different divisions. Investigation department has a vast capacity to proceed investigation equally in all regions throughout the country. As to liability for infringement of IPR, in general, according to the current legislation, there are two types of liabilities. One means administrative liability, that is a precondition that is enshrined in law, and the enforcement of administration is done by revenue service. There are different departments under revenue service of Georgia. Definitely customs department and tax monitoring department are the ones responsible for enforcement, and we have a tax department responsible for this enforcement throughout the country. As for the criminal liability, there are certain specific articles based on which we impose criminal liability, and enforcement of this is done by investigative service. As for the liability itself, we have imprisonment in criminal liability, or we have fine, seizure, destruction of destruction of goods, confiscation or destruction of goods. As regards administrative legislation is quite interesting because there are specific articles. According to the criminal law, there are three main articles, and we have here violation of the rights of copyright, neighboring right holder, and database maker. Also alteration, destruction, or counterfeit of copyright management information on copies of works, phonograms, videograms, or databases. Also in international disclosure of the essence of a patent or design registration application to such patentee, and also Article 158 regarding illegal use of trademark, service mark, or other commercial article. Also, we have criminal law on IP, a crime, infringement of the rights of the copyright holder and the owner of the database, misappropriation or co-authorship of a copyright object. Also, we have some additional qualifications regarding illegal entrepreneurial activity, Article 192, also a counterfeit, Article 197, also manufacture, importation, or sale of products dangerous to human life or health. As for the falsification, it mainly relates to food products, and we use this as an additional qualification if a product is counterfeit at a level that could be dangerous to human life or health. Also, when this similar product is involved in entrepreneurial activity, we have cases regarding forged tax document, and some individuals try to prepare or use forged tax document, and this offense is regulated by Article 210. Also, Article 214 pertains to the violation of the rules related to the movement of goods at the customs border, for example, smuggling. Also, we have additional qualification here, namely tax evasion, and that is regulated by Article 218. And deception of a user also, that is regulated by Article 219. So there are quite frequent cases of counterfeits during investigation, and in some cases, in case of charge, we apply additional qualifications. As regards the investigation structure itself, it is quite interesting, and it is not differ from other types of investigation, because according to Georgian judiciary, there is a unique or common criminal law where at the level of procedures and principles, all types of criminal investigation, we have all the same types of investigation structure. Definitely the tactic of investigation can be different, and we do have different types, or we use different tactics for investigation, and investigator can apply different type of investigation. But as for gaining or obtaining evidences, we have the common approach. The very first step is information processing and analyzing this information. Also, investigation service has applications receiving practice, and frequently we make a decision at this stage whether there are criminal signs or not. In this case, investigator is obligated to familiarize with the data or accumulated information to judge whether to initiate criminal persecution or not. After this step, we have different types of methods to gain evidences. We have standard investigative procedures, for example, interrogation and so forth, where we can do different kind of forensics activities as well. Also, we have investigative stage. We have covert activities and operational activities as well. So I have highlighted three main articles based on which we can conduct a covert investigation as well. We think that its current legislation requires to be further amended. In case of need, we conduct covert investigations, and there are frequent cases when we need operational investigations as well. For example, trademark related infringement or counterfeit, and regarding trademark infringement, when we investigate current case or ongoing case, in this case we apply this method. As for evidence gaining, you were keenly aware that you know that it is done by supervision of prosecutor's office. And in case of intermediaries and in general, the proceeding supervision is ensured by prosecutor's office. After the collecting of evidences, this process is finished with charge, and followed by judgment or verdict or sentence, and enforcement as well. In case of enforcement, apart from sentence, we make decision to destruct the goods if the value of goods, if value of goods can be applied, we can make a decision regarding confiscation or seizure, if the value of goods is high. As regards circumstances to be established by investigation, these are as follows: trademark registration, clarification when trademark, when there is a alleged case of trademark register of a counterfeit or registration related violation. SACPatenti has very good and well-developed website for open sources, where you can easily identify trademark information regarding trademark owners and so forth. It is a frequent case when in database a trademark owner is a foreign company, but the regarding representative, so we apply to SACPatent to have communication with the trademark owner. And all investigators responsible for similar cases are well aware trademark owners' representatives in Georgia. As for the main obstacles for investigators, when investigator and the prosecutor want to make a decision, we have civil disputes. In this case, we have had similar cases when the composition of a formal offense, when we detected the value, but if, for example, for a Georgian trademark, on this Georgian trademark, we had a civil dispute regarding the ownership. And it could be certain obstacle or hindering circumstances when the decision is not made regarding the ownership of trademark, and the initiator of civil dispute could be considered as affected party. And finally, when court makes a decision, this person might not be affected party or owner of this trademark. Also, we have another case when we have passive right holder, when he or she is not interested in finalizing of the whole procedure. When investigation commences, is commenced after the first investigative activities. So there are frequent cases when the purpose of trademark owner, from his or her viewpoint, it could be a satisfactory result for him or her. For example, the prevention or suspension of this criminal activity. And there are some cases when the owner has no interest to be involved in this process due to some expenses, for example. And that's why this expenses force owner to be further involved in this process. And therefore, investigator should make decision regarding confiscation or seizure of goods and so forth to finalize or to close the case. So this is the circumstances we want to highlight on when investigation service or other agencies are involved in this case. It is highly dependent on trademark owner's conclusion, what he or she thinks. We covered this topic yesterday partially, and it is worthwhile to highlight on this. This is this forensic conclusion, and in fact, affected person gives this conclusion, and we have honorable judges attending this event, also some lawyers we have in this conference hall, and they are keenly aware that affected person's conclusion could not be considered as a robust or strong evidence based on which a judge makes a final decision. So our position is to set up or establish independent experts group, some authorized private companies or a state agency, for example, to have certain agency under legal entity of public law, and to set up this experts group, having a close cooperation with SAC Patente, and this working group makes the final decision whether there is IP infringement or not. Mr. Georgi raised this issue that there are numerous trademarks, and these trademarks can be potentially registered. So a lot of trademarks are registered, and this experts group can't work on all types of trademarks. Therefore, it could be challenging, but we need to have a fair conclusion. And so for this purpose, we think that it would be very useful if we set up this working group, a dedicated working group on this trademark registration. Also, we for investigation of alleged tax evasion case, we use a special act that consists of tax evasion specific facts. But as soon as we detect this alleged case, we start to commence investigation. As for the determination of damage and quantity of goods, we we have Article 29, and that indicates more than 1,000 items, for example. And we mainly talk about Article 189, and as you remember, this article prescribes the potential harm. So potential income for owner should exceed 5,000 Georgian lari or Georgian currencies. This is very specific issue, and this field could be a field of communication or art field or other fields, and it is quite challenging, and it requires specific skill to calculate the value of this damage, and definitely investigator proves the evidences, but their viewpoint would be very supporting, and their viewpoint sharing would accelerate the investigation process. As concern responsible, as concerns the responsible person, if it is a legal entity, it depends on if it's a legal entity or a physical one, and I think that it requires further improvement. Also to identify the intention. Definitely it is very challenging for investigator to determine the intention of crime, committed offense or crime, but mainly the intention while investigating imported counterfeit goods. It's quite challenging for investigator to determine the intention of crime, especially in case when there are no evidences that this person is informed regarding trademark regulations. In this case, along with the Revenue Service of Georgia, we try to find the evidences or search for evidences that prove the intention firmly. Because the intention determination or identification is a very important aspect. As for the cooperation with agencies, frequently investigation service has close cooperation with the following agencies: SAC Patenti, or National Intellectual Property Center of Georgia, and we apply to SAC Patenti's experts' opinion. As I have already mentioned, we have specialized. We do not have specialized bureau, but SAC Patenti specialist opinion is very valuable for us and necessary as well, especially when we investigate trademark infringement. And this tight cooperation is highly appreciated indeed. In addition, we have very good cooperation with the Revenue Service. There are two main departments involved in enforcement. In addition, Audit Department. Also, we have good communication with patent attorneys, and we have a number of patent attorneys in Georgia. Some of them attend this event. They are quite active and in investigation process, as well as in discussion of similar topics. We have different kind of workshops with them, and their engagement is vital. Also, we have cooperation with forensic bureaus. We are forced to conduct a certain examination or forensic activities. Therefore, cooperation with forensic bureaus is extremely important. This slide shows the statistics regarding the IPR infringement. We do not have complete figures for 2020. This is up to May. And recently, we have been actively working on geographical indications as well and appellations of origin. And in addition, we are quite active in investigation of cases that were rare in the past. For example, while transit, Georgian geographical indications illegal application to prevent this case. There are several few cases regarding this Georgian geographical indicators application infringement. So this is information campaign. Our agency provides some information campaigns regarding trademark infringement, how to combat trademark infringement. You are well aware that information campaign plays a crucial role to raise awareness regarding this infringement, and for this purpose, so information campaign serves a very good role to raise awareness in our society regarding IPR infringement. In the past, a lot of people did not pay attention to this infringement, but we are becoming more and more active to raise awareness regarding IPR infringement as time goes by. That was all I'd like to cover during my presentation. If you have any questions, you are more than welcome.